Good afternoon, everyone. Today, I will talk about overview of licensing conditions of moneylender's license. Before I start to talk about the licensing conditions one by one, I would like to remind you that under Section 7 of the Moneylender's Ordinance, no person shall carry on business as a moneylender without a license at any place other than the premises specified in such license, or otherwise than in accordance with the conditions of a license. If the licensing court considers that the licensee has been in serious breach of any conditions of the license, the court may order to revoke or suspend the license. Now I will start to talk about licensing conditions one by one. According to licensing condition number 1, before entering into any agreement for loan, the moneylender shall ask the intending borrower to state in writing whether or not he has entered into or signed any agreement with any third party for or in relation to the procuring, negotiation, obtaining, or application of the loan, guaranteeing or securing the repayment of the loan. An agreement between the intending borrower and a solicitor in connection with the loan agreement is not regarded as a third-party agreement if the solicitor is instructed by the intending borrower to solely provide legal services, for example, vetting of the loan documentation. If the intending borrower has entered into or signed any agreement with any third party, the moneylender shall state in writing in the loan agreement the name and address of the third party, and whether the moneylender is in any way related to the third party and the nature of such relationship. This written information shall be prepared by the moneylender. The moneylender shall also ask the intending borrower to personally provide a copy of the third-party agreement, and also attach the third-party agreement to the loan agreement. You can see this is the Annex 1 of Guidelines on Licensing Conditions of Moneylender's License. It is a sample form on disclosure of the existence of third parties by intending borrower. Now this is the Annex 2 of Guidelines on Licensing Conditions. It is a sample form on recording the particulars of appointed third party involved in a loan agreement. Under licensing condition number 2, unless the third party has been appointed by the moneylender as third party and has confirmed in writing to the moneylender that he has not charged or will not charge any fees, however named, from the intending borrower and has not otherwise agreed with the intending borrower that the intending borrower pays or would pay any fees, however named, to any other party, whether for the purchase of any goods or services or not. Otherwise, the moneylender shall not grant any loan to the intending borrower. Now this is the Annex 3 of Guidelines on Licensing Conditions. It is the sample form on confirmation by appointed third party on the charging of fees. Under licensing condition number 3, the moneylender shall provide in writing to the satisfaction of the Commissioner of Police and the Registrar of Moneylenders the name, address, and identification number of the appointed third party. The third party is not considered as an appointed third party until after the name and address of the appointed third party appear on the register kept by the Registrar of Moneylenders. The set forms for reporting information of appointed third parties can be downloaded from the company's registry's website. There are 3 types of forms, that is, Form ATP1, ATP2, and ATP3. They are used to report the particulars of appointed third party, change of particulars, and termination of appointed third party, respectively. The list of appointed third parties can be found from the company's registry's website. Under licensing condition number 4, the moneylender shall not knowingly allow or permit any person to charge, recover, demand, or receive any fees, however named, from any borrower or intending borrower. The term any person includes the moneylender or his partner, employer, employee, principal or agent, or any person acting for him, or any appointed third party. For licensing condition number 4, there are 2 points that licensed moneylender shall pay attention to. Number 1, the examples of the aforesaid fees are the purchase of goods or services, or charging processing or administrative fee. And number 2, moneylender should check and ensure that there is no fee charging provision in the third-party agreement provided by the intending borrower. According to licensing condition number 5, before entering into any agreement for loan, the moneylender must give explanation to the intending borrower of all the terms of the agreement. In particular, the interest rate expressed as a rate % per annum, and the total amount of interest payable, the amounts of repayments, periodically and in total, under the agreement, the possible consequences for any default in repayment, including the taking into possession and sale of any security involved, and any overriding right of the moneylender to demand an immediate repayment. The moneylender must keep written or video or audio records which show that he complies with the requirements under this condition. This is the Annex 6 of Guidelines on Licensing Condition. It is the sample form for recording explanation of terms of loan agreement given to intending borrower. I would like to remind you 3 points regarding the licensing condition number 5. First, moneylender should clearly explain to the intending borrower all the terms and conditions of the loan agreement, but not merely the crucial part of the loan agreement. Second, even where the intending borrower states that there is no need for an explanation, the moneylender should still comply with the requirement to provide an explanation before entering into any loan agreement. Licensing Condition 5 covers all kinds of moneylenders, including the moneylenders who establish business relationship with borrowers by a non-face-to-face approach and keep records in video or audio form. Under Licensing Condition 6, the moneylender shall not obtain or collect personal data of any person from another person, or use such personal data which are obtained or collected from another person for the purpose of or in relation to the moneylender's business, if either one of the following conditions is not fulfilled. One of the conditions is the moneylender does not get the written confirmation from that other person that the disclosure or provision of such personal data by that other person for use of the moneylender is not in breach of the Personal Data Privacy Ordinance. The other condition is when the moneylender has knowledge or has reasonable grounds to believe that the disclosure or provision of the personal data by that other person for such use of the moneylender is likely to be in breach of the Personal Data Privacy Ordinance. Besides, the moneylender must keep records which show that he complies with this requirement and the provisions of the Personal Data Privacy Ordinance. According to Licensing Condition number 7, the moneylender shall not accept a subsidized flat provided by the Hong Kong Housing Authority as collateral for the loan unless the borrower has produced to the moneylender a written confirmation from the Hong Kong Housing Authority that the necessary premium for removing the restrictions on alienation on the said flat has been fully paid, or the written approval of the Director of Housing granting approval to mortgage or charge the said flat. According to Licensing Condition 8, the Chinese version of any advertisement issued or published by the moneylender for the purpose of the moneylender's business as a moneylender must clearly show the Chinese character, that is this one, and mean immediately followed by the number of the moneylender's license. According to Licensing Condition number 9, any advertisement in relation to the money lending business, whether in textual, audio, or visual form, must be fair and reasonable, and not contain misleading information, and contain a moneylender's telephone hotline for the handling complaints. And a risk warning statement, that is this one. This is the warning statement. The risk warning statement must be in the same language as that of the advertisement or relevant parts thereof, and clearly audible in the audio part of the advertisement. To ensure that the advertisement is fair and reasonable and does not contain misleading information, the advertisement must not contain information that is misleading or deceiving, must not emphasize any potential benefits of a product or service without also giving a fair and prominent indication of any relevant risks, must not disguise, omit, diminish, or obscure any relevant fact which will result in the information or message being insufficient, unclear, unfair, or misleading. Any important information must be in conspicuous text and placed in a conspicuous position in the advertisement. The advertisement should not carry information that understates the cost of borrowing and overstates the ease of borrowing. Now I will talk about the display or broadcast of risk warning statement for different types of advertisements. For advertisement in print, it should be displayed in text in at least 50% of the font size and in the same font type and color as the other contents of the advertisement that bear the largest font size. For audio-visual advertisement, it should be in clear contrast in color with the background or backdrop of the advertisement. Where it appears in an independent screenshot, it should be displayed visually at the end of the advertisement for at least 3 seconds, with a clear readout for the same duration. Where it appears throughout the entire advertisement, it should be shown clearly at the bottom of the screen. The height of each Chinese character of the statement be at least 1/15 of the screen. The height of the capital letters of the English statement be at least 1/20 of the screen, with a clear readout in the same pace as other contents of the advertisement. For Internet advertisement, which is in the form of a website banner, and when you click it, it will link to another website. In this kind of advertisement, the risk warning statement should be displayed in text in at least 50% of the font size as the other content that bears the largest font size on the landing page, and in the same font type and color as the other contents of the advertisement that bear the largest font size on the landing page. For advertisements with a static screen on the Internet, one should follow the guidance for advertisement in print, and similarly, for audio-visual advertisement on the Internet, it should follow the guidance for the display of warning statement in audio-visual advertisements. Regarding the licensing conditions number 8 and 9, I have 6 points for you to pay special attention to. The first point is that advertisements related to money lending business, including all kinds of publicity materials, shall comply with licensing condition 8 and 9. Secondly, please ensure to display the valid moneylender's license number in advertisements. Thirdly, The advertisement must contain a complaint hotline. Please note that application hotline or inquiry hotline is not equivalent to complaint hotline. Fourthly, the name of the moneylender as specified in the license, not just only a business name, must be shown in the moneylending advertisements. In fact, this is a requirement under Section 26 of the Moneylenders Ordinance. Next, if an advertisement states that certain loans are interest-free, 0% interest, it will give the impression that there are no interest or monthly fees. If a monthly administrative or handling fee is charged, the advertisement would be misleading. Lastly, it is about the posts on the social media. Moneylenders post on social media, including but not limited to its pictures, videos, and captions, may be regarded as one or more advertisements, depending on the actual situation. Moneylenders must ensure that such posts comply with Licensing Condition 8 and 9. According to Licensing Condition number 10, the moneylender and his debt collectors shall not try to recover debts, whether directly or indirectly, from anyone, for example, referees, borrowers, family members, or friends, unless such person is in law indebted to him. They shall also not to harass anyone, adopt unlawful or improper debt collection practices. The moneylender himself shall ensure personal data collected are protected against unauthorized or accidental access, processing, erasure, or other use by any debt collectors, shall comply with Personal Data Privacy Ordinance, shall maintain and monitor proper system and procedures for handling complaints and/or inquiries relating to the loans lent by him in the ordinary course of business and the debt collection activities arising therefrom, shall keep updated and accurate records of the debt collection activities of his debt collectors during the term of the license. Records should be in detail and include the dates and methods of the debt collection activities. Moneylenders must clearly understand that whether the debt collector complies with the law and the relevant requirements under the Licensing Condition number 10 in his debt collection activities is a factor for determination of whether the moneylender is a fit and proper person to carry on business as a moneylender. Moneylender must exercise proper care and diligence to monitor the debt collection activities of their debt collectors. Debt collectors should not be given a free hand as to debt recovery procedures. According to Licensing Condition 11, the moneylender shall provide information relating to his moneylending business during the term of the license as may be required by the Registrar of Moneylenders or the Commissioner of Police within such time as specified. For example, to join the Moneylenders Section annual exercise for collection of financial information and thematic surveys in which the Registrar of Moneylenders requires the moneylenders to participate. Under the Licensing Condition 12, the moneylender must establish and maintain proper system and procedures to ensure that the following parties shall be informed of and observe the licensing conditions and the provisions of the Moneylenders Ordinance. The parties concerned are the moneylender or his partners, employers, employees, principals or agents, persons acting for him, and the appointed third party. The proper system and procedure that I have set include management and supervision, personnel and training, review of appointed third parties, and record keeping. Under Licensing Condition 13, where any referee is provided in respect of the loan application, the moneylender shall, before entering into any agreement for loan, ask the intending borrower to provide a written consent signed by the referees confirming his or her agreement to act as referee in respect of the loan application, and attach the written consent to the loan agreement. If the moneylender is informed or aware that the written consent was, in fact, not signed by the referee, the moneylender shall immediately cease to use the information of the referee. Referee is a person who provides, on a voluntary basis and upon request by the moneylender, information about the intending borrower in respect of the loan application. For example, for the identification purpose of the intending borrower before entering into the loan agreement. You must note that referee is not for debt collection or for contacting the borrower after the loan agreement has been entered into. Now you can see this is the Annex 5 of Guidelines on Licensing Condition. It is a sample form on written consent by referee for loan application. Regarding Licensing Condition 14, the moneylender must comply with the Guideline on Compliance of Anti-Money Laundering and Counter-Terrorist Financing requirement for licensed moneylender, and assess the money laundering or terrorist financing risks of their business, develop and implement policies, procedures, and controls in the following 7 aspects. That is, risk assessment, customer due diligence measures, ongoing monitoring of customers, suspicious transactions reporting, record keeping, staff training, and independent audit function. You can download the guideline from our website. Now we come to the last licensing condition, that is Licensing Condition 15. Before entering into agreement for or before granting any significant increase in the amount of loan under an agreement for unsecured personal loan, the moneylender shall undertake an assessment of the intending borrowers or borrower's ability to make repayments under the loan agreement affordably, and have due regard to the outcome of the assessment in respect of affordability. In carrying out the assessment, the moneylender shall consider the intending borrowers or borrower's current income and expenditure, and their ability to make repayments under the loan agreement as they fall due over the life of the loan agreement, without having to borrow to meet the repayments, and without the repayments having a significant adverse impact on the overall financial situation. Regarding the need of the assessment must be reasonable, the moneylender must base the affordability assessment on sufficient information available to him at the time of conducting the assessment. The extent and scope of the assessment, the steps that the moneylender must take, and the evidence to be taken into account are dependent upon and are proportionate to the individual circumstances of each case. The moneylender should adopt a common-sense approach and decide what is appropriate and proportionate in the circumstances of a particular case. When making the assessment, the moneylenders should consider the following factors. They are the total amount of the principal and interest payable, the duration of the term for repayment of the loan, the frequency and amounts of the repayments, the interest rate, purpose of obtaining the loan, employment or business of the intending borrower or borrower, current credit and financial information on the intending borrower or borrower, and any other potential adverse consequences for the intending borrower arising under the loan agreement from a failure to make a repayment by the due date. As to the current income and expenditure, moneylender must take reasonable steps to determine the amount or make a reasonable estimate of the current income and expenditure of the intending borrower. When considering the current income, moneylender should take into account the salary and also other income, such as dividend and rental income. When considering the current expenditure, moneylender should consider the existing debts and the essential living expenses and other expenditure which is hard to reduce to give a basic quality of life. Moneylender may also consider the savings and assets of the borrowers. Besides, where it is reasonably foreseeable that there is likely to be a reduction in the income or an increase in the expenditure, which could have a material impact on the ability to make repayments affordably and without the repayments, significantly affecting their overall financial situation. The moneylender must take reasonable steps to estimate the amount of debt reduction or increase and take it into account in the assessment. Lastly, the moneylender must also keep written or video or audio records which show that the requirements under this condition have been complied with. The moneylender should establish, implement, and maintain clear and effective written policies and procedures and set out the principal factors it will take into account in carrying out the assessment. Regarding licensing condition 15, we have 4 points for moneylenders to pay attention to. First, self-declaration of income and expenditure by the borrower or intending borrower is not an affordability assessment. The moneylender must base the assessment on sufficient information available with evidence to show the assessment is carried out by the moneylender. For example, by signing and dating the written assessment. Second, assessment record must show the factors that the moneylender has considered, especially the special factors. For example, if the expenditure of a borrower is larger than his income, but the moneylender still grants a loan to him, then the moneylender should state clearly his assessment and the reason for granting the loan. Thirdly, the moneylenders must ensure the information shown in assessment matches the information provided by intending borrower or borrower. For example, information from loan application or proof of income. Lastly, the moneylender should adopt a common sense approach and decide the reasonableness of the information provided by the intending borrower. The moneylender should require the intending borrower to provide relevant supporting documents, if appropriate, and keep records of the supporting documents. For example, if an intended borrower claims that his income on a part-time job is $100,000, then moneylender should ask for the relevant supporting document. Another example is that if an intended borrower claims that he had no living expense or the expense is extremely small, then moneylender should seek for an explanation. If the borrower fails to provide a reasonable explanation, then the moneylender should also consider whether he can make a reasonable assessment. If not, then the moneylender should not grant the loan to this borrower. We have gone through all the 15 licensing conditions one by one. Lastly, I would remind you that in addition to new loan agreement, the above-mentioned licensing conditions relating to loan agreement also apply to the extension or renewal of loan agreements. When entering into any extension or renewal of loan agreements, moneylenders are also required to comply with the relevant licensing conditions. The company's registry has issued 2 main guidelines. They are the Guidelines on Licensing Conditions of Moneylenders License and the Guidelines on Compliance of Anti-Money Laundering and Counter-Terrorist Financing Requirements for Licensed Moneylender. The other guidelines include Guideline on fit and proper criteria for licensing of moneylenders and Guideline on submission of business plan by applicant of a moneylender's license. All these guidelines can be downloaded from our website. If you have any inquiries, you may call our hotline or send an email to us. This ends my part for this seminar. Thank you very much.